It's the kind, yeah, just for a moment. And then definitely you can switch off because I myself will be switching off the video and we'll be having this session in a form of an interactive session. Jitendra sir, Deepak Garg sir, Vikas Kumar ji, and others would be grateful if I can have just a video on for a moment. Okay, thank you. Thank you, sir. A very warm good morning to all the dignitaries and the participants for attending this session of today, consisting of a stakeholder consultation committee and liquidation estate. May I know how many of you have completed with the liquidation process or are undergoing the liquidation process as a liquidator? Any one of you?
As a voluntary liquidation.
I am doing
Sorry.
one.
Great. Good to know, Suresh sir. You are undergoing one, right?
Yeah.
So have you published the notice and the publication part is done on your behalf or it is prior to that?
In fact, I'm doing two. One is going on. Second one
Okay.
has been stayed by NCLT. The first one I did everything. I made public announcement. I consultant SCC. I've been making meetings. Then I made valuations.
Correct.
Then I published auction. Then that auction has been stayed by NCLT.
Okay. Okay. That has been stayed by NCLT as of now, is it?
Yeah.
Oh, okay. Okay. So now the topic which we are covering today, I have also done two of the liquidation cases. Both of them are undergoing the process. So I'll share my experience, the difficulties, the challenges faced by me, or I'm still facing the challenges, and how can we move ahead. So I think with that practical experience, we can share our views on how can we move ahead in this, what all the protocols needs to be followed, the things to be taken care of, right?
Right.
So, okay then. I'll be just sharing the screen. Is it visible? Can anyone just confirm whether
Yes,
the screen
ma'am.
is
Yes, ma'am. It's
okay?
visible.
Okay, okay. Thank you.
Yes, it's visible.
Okay, thank you. Now, understanding of the Insolvency and Bankruptcy Code, starting with the basic, what is IBC? I am pretty sure that you all must be knowing it. It provides a time-bound process, typically 330 days for resolving insolvency through either revival or liquidation. In the case of Byju's, I think you all must be aware that the timeline has been fixed till 330 days. But as per again the order for maximization of the value, the basic code of the IBC that the company needs to be resolved. So again, the timeline has been extended. Okay, until and unless the resolution plan is received and discussed and approved upon, the timeline can be extended beyond 330 days. The Insolvency and Bankruptcy Code is a legal framework to resolve cases when companies or individuals are unable to repay their debts. Stakeholder Consultation Committee comes into existence after the liquidation order is passed under Section 33 of IBC. While approving a plan under Section 30 or deciding to liquidate the corporate debtor under Section 33 as per Regulation 39D, the Committee of Creditor may, in consultation with RP, fix the fee payable to the liquidator. So here the important word written in Regulation 33 is may, right? The period, if any, used for compromise or arrangement under Section 230. The period, if any, used for sale of assets under 32E and F of the IBBI liquidation regulations 2016. So here I would like to seek your attention with respect to 32E and F. 32E is sale of assets as a going concern, sale of CD as a going concern, and 32F is Sale of business as a going concern. Can anybody let me know what is the difference of 32E and 32F in this? Anyone? किसी ने किया 32E या F में? सेल ऑफ असेट्स के लिए ऑक्शन नोटिस जब निकाला, एनीवन? वुड रिक्वेस्ट द पार्टिसिपेंट्स की लेट्स कीप दिस एज एन इंटरैक्टिव सेशन। एक तरफ से बोल के थोड़ा बॉर्डम आप लोगों को सुनने में भी हो जाता है, मुझे बोलने में भी हो जाता है। वी आर हियर टू शेयर आवर एक्सपीरियंस, let know what challenges we have faced or are still facing. Yes, Suresh sir.
Yeah. Tell me, madam, what I'm saying. You asking something?
Yes, sir. I have asked anybody can let me know 32E and F difference. 32A and 32F. Sale of CD as a going concern. Sale of business as a going concern. Okay, I'll explain it. 32E is initially in one of our my recent cases, I have published the auction notice with respect to 32E, that is sale of CD as a going concern. But the auction got failed. So with the advisory, with the advice of the SEC, and I also recommended that, okay, if the auction has got failed, we can move to 32D as well. 32D is for sale of asset in person. Now, when the CD has a different business, different kind of business under one name only, at that time, they can get the company sold under 32F also. That one business of that CD can be sold as a going concern. Is it clear now? Great, sir. And to others as well. Once liquidation is initiated, the liquidator shall constitute. Here, please remember whatever wordings has been used in the act, shall, may, whatever is written, that will help us in filing of any of the applications before the court. Whatever work is to be done as a liquidator, what is must, what is may. Once
Madam,
liquidation,
business means the name of the company. Or
business
the
means, sorry,
name of the company.
correct, correct,
Name of the
correct, correct.
company.
Huh.
The
Yes,
other
sir.
one is the asset of the companies.
Correct. Once liquidation is initiated, the liquidator shall constitute the stakeholder consultation committee under Regulation 31A of IBBI Liquidation Regulations 2016. Coming to definition of consultation committee and stakeholder as per IBBI Liquidation Process Regulations. Regulation 2BA of IBBI Liquidation Process Regulation defines consultation committee means the stakeholder consultation committee constituted under sub-regulation 1 of regulation 31A. And regulation 2K means stakeholder means, okay. So there is a consultation committee, there are stakeholder who will form combinedly. Stakeholder consultation committee means the stakeholder entitled to distribution of proceed under section 53. So definitely whatever the stakeholder will receive will be as per the distribution of proceed under section 53. That is already been specified. The hierarchy has been specified. Who will receive the amount on a priority basis? That is definitely the liquidation or the CIRP cost. Second, comes over here then the secured creditors. Along with that comes the workmen who have worked for 24 months, plus the employee who have worked in the employment of that company for 12 months. Accordingly, this hierarchy has been decided. You must be aware of this section 53. So these 2PA and 2K. Further, we'll be discussing preparation of list of stakeholders as per regulation 31. As per regulation 31(1), liquidator shall, again the word is used, shall prepare a category-wise list of creditor based on proof of claim submitted and accepted, right? But there could be some exceptions to this that I'll be discussing as well. Based on the proof of claim submitted and accepted. So claim needs to be submitted and accepted by the liquidator containing the following details: amount of claim admitted if applicable, extent to which debt or dues are secured or unsecured if applicable, details of stakeholders, proof admitted or rejected in part or wholly. As per Regulation 31(2), the liquidator shall file the list of stakeholders with the adjudicating authority within 45 days from the last date of receipt of claim. Now, certain things that needs to be taken care over here. If the claim is not submitted by any of the claimant in the liquidation process, is the liquidator bound to admit the claim? Can anybody revert me on this? Can anyone? Well, I'll tell you. Amount of claim, if not submitted by the list of stakeholders, by any of the stakeholders, then too, if there is a workman debt that has been specified in the balance sheet, then it becomes the duty of a liquidator to admit that claim, as in Regulation 19 of Liquidation Regulation 19(4). It is specifically written the liquidator may admit the claim of a workman or an employee on the basis of books of accounts of corporate debtor if such workman or employee has not made a claim. Now, the word is used may, means if the background is not clear or the details could not be found of any workman or an employee from that books of accounts, the details could not be extracted, then the liquidator is not bound to admit the claim. But if the details are found in the books of accounts to which the liquidator have the sufficient information through the books of account, then it is a duty of liquidator to admit the claim, although the workman has not submitted the claim. I hope I am clear till here. Any doubts with the Regulation 31(1) or the Stakeholder Consultation Committee definition? We can stop here and discuss. Okay, so I assume there is no issue as such. As per so coming over to as per Regulation 31(3), liquidator may apply to the adjudicating authority to modify an entry in the list of stakeholder filed with the adjudicating authority when he comes across additional information warranting such modification, and shall modify the entry in the manner directed by the adjudicating authority. Now, list of stakeholder, as I cleared in the previous slide, as per Regulation 31(2), liquidator needs to file the list of stakeholder with the adjudicating authority within 45 days from the last date of receipt of claim. Now, liquidator also has a right that any modification required in the list of stakeholders, when he come across certain additional information, that can be filed with the adjudicating authority through an additional affidavit. As per Regulation 31(4), the liquidator shall modify an entry in the list of stakeholders filed with the adjudicating authority in the manner directed by the adjudicating authority while disposing of an appeal preferred under Section 42. Now, here it becomes the duty. You could see the difference. In 31(3), the word may was used. In 31(4), the word shall is used with respect to the liquidator while disposing of an appeal preferred under Section 42. Now, what Section 42 says, that a creditor may appeal to the adjudicating authority against the decision of the liquidator, accepting or rejecting of the claim within 14 days of the receipt of such a decision. Now, through an appeal, if any such information has been received that their claim is not being accepted by the liquidator, so now here the adjudicating authority needs adjudicating authority direct the liquidator, and then accordingly liquidator shall file the list of stakeholder entry, needs to modify an entry in the list of stakeholders. So please do check with 31(3) and 31(4). As per Regulation 31(5), the list of stakeholder as modified from time to time shall be available for inspection by claimants, available for inspection by members, partners, directors, and guarantors, displayed on the corporate data's website, if any, filed on IBBI electronic platform for dissemination. Stakeholder Consultation Committee, Regulation 31(a). what 31A speaks. The liquidator shall
Madam,
constitute.
Madam, they have to
Yes.
extinguish their security interest.
Sorry, sir.
They have to extinguish their security interest. In
Who
order
has to
to
that also we'll be discussing it later. This you are talking about the secured financial creditor, right?
yes, to be a
So
member of
that thing will be discussed later. In
SCC,
sorry,
to be a member of committee of SCC.
sir, they have to relinquish their secured interest if they are a
Yes,
secured financial creditor, sir. That thing
yes,
will be discussed
yes.
later on. Don't worry, sir. Definitely, sir. That will be
Okay,
discussed. Okay,
okay.
thank you. Now, 31A, the liquidator shall constitute a consultation committee within 60 days from the liquidation commencement date. Now, what is liquidation commencement date? Means the date on which liquidation proceeding commence under section 33 or 59 as applicable of the Insolvency and Bankruptcy Code. So 33 talks about liquidation, 59 or section 59, that is voluntary liquidation. The committee comprise all creditors of the corporate debtor based on the list of stakeholder prepared under Regulation 31. Now, this amendment has come in the year 2022. The committee comprise of all the creditors of the corporate debtor, wherein where you check in the COC. So COC that will be discussed. COC में एक specific people होते हैं जिनसे consultation committee बनती है. एससीसी में जितने भी क्रेडिटर्स हैं जो अपना क्लेम फाइल करते हैं या अगर वो क्लेम फाइल नहीं करते हैं, इफ द लिक्विडेटर फाइंड देम थ्रू द बुक्स ऑफ अकाउंट्स दैट देयर क्लेम नीड्स टू बी एडमिटेड ऑल्दो दे हैव नॉट फाइल्ड देयर क्लेम, सो दे आल्सो बिकम अ पार्ट ऑफ अ consultation committee. What is the difference over here when you talk about the government people? Okay, so government, the statutory dues. In COC, they don't have a voting right. Okay, they are treated as an operational creditors, or the statutory, they are treated as a under the category of government. But in stakeholder consultation committee, they have a voting percentage over here. So this amendment came in the year 2022. Now, what is the role of the SCC? To advise the liquidator. So this is an advisory role. This is not binding on the liquidator. We'll be discussing in the further slide. Remuneration of, okay, yeah. Coming over to 31A1A, remuneration of professionals appointed under section 7. Appointment of professional. In the normal parlance, what happens in the last COC meeting where the liquidation that the company needs to go into liquidation because there is no resolution plan received or resolution plan received is not viable. On that basis, if the COC rejects the plan, then the COC and the RP decides that that the company needs to go into liquidation as per section 33. Now, when they go into liquidation, certain costing has been, certain costing needs to be decided, may be decided, may not be decided. There is no compulsion that what shall be the fee of the liquidator, who all needs to be appointed, what shall be the bar, okay, ki this much amount needs to be paid to the legal person or any of the professional needs to be appointed over there. In case if not discussed in the last COC meeting, then in this COC, in the SCC meeting, remuneration of professionals, I'll just let you know what, as per Regulation 7, what Regulation 7 speaks appointment of professionals. A liquidator may appoint professionals to assist him or her in discharge of the duties, obligation and function for a reasonable remuneration, and such remuneration shall form part of a liquidation cost. Liquidator shall not appoint a professional under sub-regulation 1 who is a related party or has served as an auditor of the corporate debtor in last 5 years preceding the liquidation commencement date. A professional appointed or proposed to be appointed under sub-regulation 1 of Regulation 7 shall disclose the existence of any pecuniary or personal relationship with any of the stakeholders. So, liquidator has that authority provided SCC approves it. Sale under Regulation 32, sale of assets, that is 32A to F. 32A is a standalone sale, 32B slum sale, 32C sale of set of assets collectively, sale of assets in parcel, corporate debtor as a going concern, or business of a corporate debtor as a going concern. The process also involved. Now, this important point needs to be discussed at length over here. The process also involves setting pre-bid qualification, determining a reserve price, implementing a marketing strategy, and conducting the auction process. I'll share my experience over here. In You must be aware that in the month of April, this Banknet portal came into picture. That whatever auction will be conducted, that will be through the Banknet portal. That came in the month of April, right? Now, in July end, FAQ was presented by the IBBI that the documents also needs to be uploaded on the Banknet portal. We published the auction notice by July end. Okay. Now I received a call from IBBI that, madam, you have written in your auction notice that the documents should be received on your case specified mail ID. And if the documents are not in order, then you can ask them to do so. I mean, yes, sir, definitely. Then IBBI people told, we have published our FAQ. You go through it, because then they rejected our auction notice plea or whatever we have filed. So they rejected on the IBBI site. We have gone through the FAQ. So, these things were so closed. I think, 21st of July, they have published the FAQ. And on 23rd or so, we have made the paper publication of that auction notice. And then auction notice also needs to be uploaded on the IBBI site. You must all be aware of this thing. So these things happens. We need to keep ourselves updated. That was
Now,
an
is it
over.
mandatory? Is it
Yes.
mandatory to use backnet?
Yes, sir, it is very much mandatory. Without that, the whatever you have made the paper publication and trying to upload on the IBBI site, they will not accept it, and it will be counted as a professional misconduct. It is a compulsion. So that is what I am telling you, because in the month of April it came. We have to keep ourselves updated, whatever amendments have come across on the IBBI, because they used to normally publish it on the IBBI site itself. But about the FAQ, they never gave any such indication that FAQ has been published. So because of that, we could not view, or we could not go through the FAQ, because whatever amendments are there, you only go through that amendments. So now I came to know basically that, okay, आपको कोई चीज अगर publish करनी है या कोई आप अलग करने जा रहे हैं कुछ, तो then you should go through the FAQ as well prior to doing anything. So एक तो what happened over there, again we need to do the paper publication with a corrigendum. So
Okay.
this also involved the cost. We need to intimate to the SCC. So a double burden was there. Now I'll be discussing it. The process also involves setting up pre-bid qualification. Pre-bid qualifications also needs to be decided, that whatever all the annexures and everything in the process document, whatever you prepare, please do go through the Banknet portal and the FAQ that has been published on the IBBI site, and then prepare your auction notice and the process document. Determining a reserve price definitely is determined with the consultation of the committee. Implementing a marketing strategy normally is applicable if the auction is not very successful. In my case, this will be the fourth auction we will be publishing by mid of September. 3 auctions had been failed due to one or the other reason, and conducting the auction process. So everything needs to be clearly discussed in the stakeholder consultation committee itself. Whatever your views are there, and whatever the stakeholder consultation committee says, you being a liquidator, it is your duty that whatever the market prevails, accordingly, you should guide the stakeholder consultation committee that it should be done this way. You should put your recommendation. It is up to the stakeholder consultation committee. You try to convince them first. And if they are not convinced and you want to go in a separate manner, then definitely you need to file this application before the adjudicating authority specifying the reasons of it. Coming to fee of a liquidator.
No, if you don't get any bid, if you don't get
Sorry?
any bid, if you don't get any any bid from backrent,
No,
if you
you,
don't,
no, sir. Sir, okay, okay. Let me just go through. Now, there is a specific timeline given that uh, before the last day of the auction, the last 2 days, you should get the EMD, right? And the process document or the pre-bid qualification document should be submitted by the auctioneer. If we don't receive the EMD, then on the same day of the auction, we can mail it to the banknet that we have not received the EMD, so better you cancel this auction.
if you
Because
don't,
we cannot
if you
yes,
don't get any offer,
that is what I am saying, sir. If I don't get any offer, say today is 6th, right?
yeah,
Today is 6th of September. On
hmm.
8th, we are about to do the auction. So we need to wait till 6th, the EMD to be received and the pre-bid qualification documents. Okay, now it is up to us. It is our right, you can say, or it is our prerogative that, okay, we can entertain the documents to be received till 7th as well. So accordingly, we have to tell this to the banknet. Banknet portal also have certain technical issues what we have faced in our last auction. There were two auctions because there were two premises of our company located in different states. So one state auction was completed on that, and for the second place auction that got failed. So again, we are in the process of doing the paper publication and getting the auction notice published. I think I'm clear, Suresh, sir, or you have further queries so
No,
that we can
madam,
let you clarify.
I'm not clear. My
Okay,
point
okay.
is, if you don't get any bid
Uh,
through backnet,
okay.
can you then in that then can you go to some other
No, sir. No, no, no,
e-auction?
no, sir. Then you can't go to any other portal. कि okay,
Okay.
अगर ये बैंक रेट से नहीं हो रहा है तो आप कहीं
Ah,
this is a compulsion. It is my kind
yes,
request. You
yes, yes.
kindly go through the April issue, whatever has been published on the IBBI site about the banknet portal and the FAQ as well, sir. You
I
will
do.
have a clear picture because अभी हमने ये सारा practically किया है जो उसमें problem face करी तो
Ah,
I can
ah.
share my difficulty, my views, my challenges with you people. Okay.
Okay, thank you
Okay,
very much.
thank you. Thank you, sir. Coming to fee of a liquidator, the very important part, because we once are there as a professional, we definitely are not here for charity. But ये fee का इतना बड़ा issue है with the IPs, ये फी एक तो कोई हमारी डिटरमाइन नहीं करता है, फर्स्टली डिटरमाइन होती है तो पे नहीं करता है द बैंकर्स और द फाइनेंशियल इंस्टीट्यूशंस, और जो भी स्टेक होल्डर कंसल्टेशन कमिटी है दे से कि ओके जो भी पैसा है वो आपको लिक्विडेशन एस्टेट में से मिल जाएगा, बिकॉज वो तो आपका प्रायोरिटी पे ही है. तो वी हैव टू वर्क टिल देन विथ जो अभी हम कर रहे हैं सर, अभी भी हमें कोई पैसा नहीं मिल रहा है. देयर इज वन ऑफ आई जस्ट वांट टू शेयर वन ऑफ माय इंटरेस्टिंग केसेस अबाउट लिक्विडेशन. COC in the last meeting decided the liquidation cost, okay, to be only 2300 rupees. कि इतनी ही है ये liquidation value 2300 रुपए है. Liquidation cost will be 1 lakh rupees. I don't know on what basis they have assessed, right? And whosoever was the RP, I'm talking about this case in 2021. Thing has happened. I was on the panel of IBBI. So the RP refused to be a liquidator, definitely because there was no assets in the company. So NCLT, while passing the order, recommended my name because I was on the panel of IBBI, that Chaya Gupta to be appointed as a liquidator. Then I constituted a consultation committee. In the consultation committee, there were 4 banks. With those banks, I discussed that on what basis you assess the liquidation value and the liquidation cost. They told we are not aware, ये तो आरपी ने लिख के दिया है हमें. एंड देन मैंने कहा सर व्हाट अबाउट माय फीस देन. बोले कोई एसेट्स नहीं है, आपको रेगुलेशन 4 के हिसाब से जो होगा मिल जाएगा. एसेट्स नहीं है. नाउ देयर वर देयर वाज अ चांस कि डायरेक्टर ने इन द लुक बैक पीरियड में ही कुछ अमाउंट विड्रॉ किया था. सो दे टोल्ड कि प्यूफे एप्लीकेशन आप फाइल करवा दीजिए मैम, जो प्यूफे का आउटकम होगा अगर उससे कुछ होता है तो देन वील सी टू इट. प्यूफे का आउटकम अभी तक कितनों का हुआ है आई एम नॉट अवेयर सर. मैंने तो नहीं देखा इन पास्ट 4-5 years कि कोई प्यूफे का आउटकम हुआ जिसके बेसिस पे फी हमें मिल गई हो. then I requested them, okay, when the company don't have any assets, it is better to go into direct dissolution. The PUFA application can be discussed accordingly. वो तो आप बाद में भी कर सकते हैं भाई, कंपनी का एग्जिस्टेंस नहीं भी हो तो PUFA आप लोग असाइन कर लीजिए उसे, और then you can accordingly fight for the PUFA application because there are no assets in the company. They told कि okay, no, we don't want to dissolve the company as of now. You being a liquidator, carry on with your duties. जो होगा outcome, we'll see to it, and let's see what happens. In the 11th or 12th SCC meeting, my repeated requests were there that free me from my duty, because आपको भी पता है कि IBPI के compliances करना है, और आपको continuously progress reports फाइल करना है without any, और आपको SCC भी कन्वीन करना है. So I requested, so then they agreed कि ठीक है, अभी हमें भी इसमें कुछ दिख नहीं रहा है, you better file a dissolution application. I filed a dissolution application. This dissolution application I filed in the year 2023. In last 2-3 months also, I got an outcome from the adjudicating authority that this dissolution application is a prematured application. So on that ground, we dismiss it. Again, I have to perform my duty. Again, ABCD, I have to get it done. I called a SCC meeting, I requested them about my fee. Bole, we already told you, whatever regulation 4 says, we are bound to pay by that. मैंने कहा, but you don't have any assets. तो बोले, आपको पता तो है. You either go to NCLT. मैंने कहा, वो तो मैं गई हुई हूँ. About my fees, the application is already pending and already sub judice. तो बोले, then whatever will be the outcome of NCLT, you will be getting the fees. और आपको पता है NCLT हो या NCLAT हो, they don't intervene about the fee of a liquidator. ऐसा किसी का कोई एक्सपीरियंस रहा है? किसी ने कोई एप्लीकेशन फाइल करी है, या ऐसा किसी का कोई केस है जहां उन्हें फी नहीं मिल रही है? So that we can have a healthy discussion over here.
But one thing I fail to understand, if there is no asset, then why does dissolution didn't take place?
Why? What, sir?
If there is no asset,
हाँ,
then why dissolution application didn't pass? Dissolution.
sir, you are not very clear. Can you come again, please?
What
If there
अगर
are
कोई
no
asset,
assets, then
अगर कोई asset नहीं है, तो फिर dissolution
हम्म
क्यों नहीं हुआ? Dissolution क्यों नहीं हो रहा है?
सर, डेसोल्यूशन एप्लीकेशन के लिए हमें एससीसी की कंसेंट लगेगी ना. दे वर नॉट
अगर अगर कुछ
अग्रीइंग
asset
टू
ही
इट.
कुछ भी नहीं है, अगर कोई
सर,
asset,
correct,
please.
correct, sir. For this reason only, they eventually agreed in 11th or 12th, I think, SCC meeting that, okay, there are no assets. You better go for dissolution. Okay, I filed the dissolution application. Court dismisses my dissolution application saying it is a premature because the PUFA application is pending, my fee application is pending, and EPFO also filed the case in the year 2023, much later after filing my dissolution application.
अच्छा, पोपे was there.
तो डेफिनेटली सर, प्यूफे भी है तो देयर इज अ रेगुलेशन कि प्यूफे कैन बी ट्रीटेड सेपरेटली, डिसोल्यूशन कैन बी ट्रीटेड सेपरेटली. देयर इज अ स्पेसिफिक रेगुलेशन अबाउट इट, टू
In
व्हिच
that
आई.
case, you should ask for you should ask for your remuneration. You should ask for your fees.
सर आपको लग रहा है एससीसी मानता है? यही तो मैं बोल रही हूँ कि
SCC नहीं,
एससी.
NCLT से direction मैम, NCLT से
Sir,
direction लात.
NCLT said I have already filed an application with respect to my fee. Let's see, I think it will be coming somewhere in the month of September
Yes,
only,
yes,
my application.
yes, yes.
But sir, and that is what I again told you. Whatever orders I have read of NCLT and NCLAT, they never intervene about, or they never want to indulge how much should be the fee of a liquidator. They at the time already guided us that you sit along with the SCC, discuss with your fees, and then come back to us again. Everything has been done, taken care of, but there is no outcome. That's why I requested, अगर ऐसा किसी को कोई किसी ने फेस किया है, because the court is also not intervening. Once even the court intervenes and say कि नहीं, this much amount should be given to the liquidator, whatever amount, because whatever I have quoted, the SEC feels ये तो बहुत ज्यादा है, assets नहीं है, हम आपको कैसे दे दे और क्यों दे दे. मैंने कहा okay, then you set across as per the court order. बोले नहीं, जितना लिखा है लिक्विडेशन वैल्यू 1 लाख है वो आप बोले ले. मैंने कहा सर, आई एम वर्किंग सिंस 2021 एज अ लिक्विडेटर फॉर योर कंपनी. नाउ यू आर सेइंग कि 1 लाख रुपीज आप ये एंटायरली ले लीजिए एज पर द लिक्विडेशन वैल्यू. That is not acceptable to me. बोले okay, then whatever the NCLT decides. So we are in such a mess now कि NCLT भी नहीं बताते हैं as per their norms, और SCC भी नहीं देना है हमें. So these are the situations. मैं मेरा डिस्कस करने का सिर्फ यहाँ यही इंटेंशन है सर, कि आपकी फीस कोई भी लिक्विडेटर की हो, that should be discussed at a very initial stage. If they are not allowing, go to the court. सर जबकि मैं फर्स्ट SCC मीटिंग में ही उन्हें ये सारी चीजें बता चुकी थी, एंड आई हैव फाइल्ड, कब से मेरी एप्लीकेशन पेंडिंग है सर कोर्ट में अबाउट द फीस, अभी तक कुछ आउटकम नहीं आया है. Let's cross the fingers and hope for the best, sir. Okay. Coming under Regulation 35(2), which states that if after consultation with the consultation committee constituted under Regulation 31A, liquidator is of opinion that a fresh valuation is required, he shall, within 7 days of liquidation commencement date, appoint two registered valuer for each category to determine the realizable value of the asset or business of a corporate debtor as specified under clause A to F of Regulation 32. I hope this point is clear about the valuation. Because whatever valuation was done during the CIRP period till the time the liquidation commences, so it is almost more than a year. And if the land is situated or the plant and machinery are of such nature that they are much depreciable, that it is my recommendation to get a fresh valuation done after obtaining a view, or after the consultation with the consultation committee, because I have already get it done in one of my cases, the fresh valuation, because the land value might appreciate, and the type of plant and machinery are there. So for these two reasons, there should be a fresh valuation. The manner of pursuing proceedings shall relate to preferential transaction undervalued, that is PUFE, including the distribution of proceeding arising from such proceeding. If any PUFE application is filed during the CIRP period, all the details needs to be disclosed and detailed before the SCC. Reviewing of marketing strategy in case of failure of sale of corporate data as a going concern. I think I have discussed this is at length. Whatever the failure of auction was there, the 3 times there was a failure of our auction. So then with the consultation committee, we reviewed our marketing strategy, and with the 2 properties of this company, one of the property that is located at a different place, the successful auction has been held. We are in the process of issuing LOI after going through the documents and all. And for the second, again, we are going for the public auction with the consultation committee consent. Continuation or initiation of legal proceeding by or against the corporate debtor. Now, this is also important thing. Whatever legal proceedings were going on during the CIRP period, that also needs to be discussed and disclosed to the stakeholder consultation committee. Any new proceedings needs to be initiated, or any continuing legal proceedings by or against the corporate debtor, that needs to be discussed and disclosed to the stakeholder consultation committee.
Madam, may I interrupt?
Sure, Deepak ji, tell me.
Madam, in case the PF department sends some notice that this is the interim claim, or this is not assessed, but this is the tentative claim during the liquidation period. So what should be our stand?
सर अब ये EPFO का मैटर इज सच डिफरेंट मैटर. आई थिंक वो मुझे भी एक चीज है जो अभी फर्दर मैं डिस्कस करूंगी उसको. आपका पॉइंट वैलिड है. EPFO वाले पीपल आर सो मच aggressive nowadays
Yes.
that after even filing the dissolution application, as I told, they file their claim. अब EPFO का कोई क्लेम है तो अब मैं वो एंटरटेन करना चाहिए. देखिए, दे दैट इज वैसे भी दैट इज आउटसाइड द लिक्विडेशन एस्टेट. दे हैव द अथॉरिटी कि वो पैसा तो ले सकते हैं सर. और अगर उन्होंने कोई क्लेम फाइल किया है यहाँ पर, तो वो एज पर नॉर्म्स हमें एक बार देख के, और वो CIRP पीरियड में भी उन्होंने किया था और यहाँ भी किया है क्या सर? दीपक जी,
CIRP में नहीं किया, अभी किया है. और इनका इनकेस अभी वो क्लेम डिटरमिन नहीं है, वो तो कह रहे हैं इंटरिम क्लेम है हमारा.
डिटरमिन कैसे नहीं है?
नहीं, वो कहते हैं कि ये टेंटेटिव क्लेम है, हम इंटरिम क्लेम है. इंटरिम क्लेम करके उन्होंने एक कम्युनिकेशन भेजा है.
आपने उसमें क्या स्टैंड लिया दीपक सर?
हमने तो ये लिया है कि अभी हमारे पास कोई इस पीरियड का कोई एम्प्लॉय नहीं था तो ये इसमें कोई और हमने जो डॉक्यूमेंट्स मांगे थे हमने दे दिए, बैलेंस शीट वगैरह, कि इसमें कोई हमारी एम्प्लॉय कॉस्ट ही नहीं थी।
जी
तो
जी जी।
तो दिस क्लेम डज नॉट सर्वाइव, मतलब ये जो आपकी
करेक्ट।
कंटेंशन है, इट डज नॉट
जी।
सर्वाइव।
करेक्ट सर,
और
तो उनका
और
उस पे कोई रिवर्ट आया है?
नहीं, अभी कुछ नहीं आया। एंड
हम्म।
इन वन ऑफ द मैटर, वन ऑफ द अदर मैटर, दे हैव सेंट कि हमें इंस्पेक्शन के लिए बुक्स ऑफ अकाउंट है, सो कैन दे डू सो?
सर देखिए, उन्हें अथॉरिटी तो है,
जी
ये आपको भी पता है,
जी
राइट?
जी।
आप नहीं करेंगे, दे विल बी फाइलिंग द एप्लीकेशन बिफोर द एनसीएलटी। अगेन सर, आई टेल यू, इन वन ऑफ माय केसेस जिसमें हमने रेसोल्यूशन, डायरेक्ट रेसोल्यूशन एप्लीकेशन लगा दी है
जी।
आफ्टर द सीआरपी पीरियड। व्हाट हैड हैपेंड, जब हमने रेसोल्यूशन एप्लीकेशन जिस दिन हमने अपलोड करी, उस दिन उनका क्लेम आ गया हमारे पास। वी हैव इंटीमेटेड देम कि आपने क्लेम उन्होंने पहले ही फाइल किया हुआ था सर, दैट वाज सब जुडिस, राइट? उन्होंने हमसे इंस्पेक्शन डॉक्यूमेंट्स वगैरह, जैसा आप कह रहे हैं ना दीपक सर, दे हैव इंक्वायर्ड फ्रॉम अस अबाउट द इंस्पेक्शन डॉक्यूमेंट्स, हमने उन्हें सब दे दिया इंस्पेक्शन डॉक्यूमेंट्स। एज आई टोल्ड कि हमारी ड्यूटी होती है वो देना, राइट? उनके पास डॉक्यूमेंट्स रहते नहीं है, दे इंस्पेक्टेड व्हेन द डे वी फाइल द रेसोल्यूशन एप्लीकेशन, उस दिन वो बोलते हैं कि आपका इतना क्लेम बन रहा है। वी रिवर्टेड कि हम तो रेसोल्यूशन एप्लीकेशन फाइल कर चुके हैं सर अब। The matter is still sub judice before the court. Now they have filed their claim before the NCLT. He asked the RP to admit our claim. So such thing happens sir. जो आप कह रहे हैं वो actually I think यहाँ बहुत सारे IPs यही फेस करें कि हमें, अभी आपने तो मना ही कर दिया कि आपका तो है ही नहीं, तो आपने उनको रिजेक्शन का मेल भेजा है या क्या भेजा है सर?
नहीं, रिजेक्शन, हाँ रिजेक्शन का तो इनफैक्ट इट इज नॉट ए क्लेम एक्चुअली, तो इंटरिम क्लेम करके तो कुछ होता नहीं है।
Correct sir. There is
है ना?
no, correct sir. There is no terminology for an interim claim.
यस।
That's what it said. Better you rejected. मतलब आप उन्हें बोल दीजिए कि अभी आपका क्लेम ही सस्टेन नहीं कर रहा है।
राइट
आपने ना
राइट राइट।
प्रॉपर फॉर्म दिए, ना कुछ दिए हैं हमें, ना आपने कोई उससे रिलेटेड डॉक्यूमेंट्स दिए हैं।
Madam, when there is moratorium,
यस सर।
how can they inspect or to the
यस
when moratorium is in effect,
जी।
then how can they inspect or ask for books and all?
सर देखिए ना क्या होता है, अगर ईपीएफओ को देखिए, दिस इज आवर ड्यूटी कि कंपनी लिक्विडेशन में आई है या सीआईआरपी में आई है,
Hmm.
वी नीड टू इंटीमेट टू द डिपार्टमेंट्स टू फाइल देयर क्लेम, राइट?
Perfect,
राइट
perfect,
सर। अगर
perfect.
उनके पास कोई डॉक्यूमेंट्स नहीं है जिसके बेसिस पे वो एक बार इंस्पेक्शन करना चाह रहे हैं या डॉक्यूमेंट्स हमसे मांग रहे हैं, बिकॉज नॉर्मली ईपीएफओ के पास नहीं होता है सर।
हाँ, मांग रहे is different. मांग रहे is okay. Notice
जी
भेजना is different.
सर, बट वी नीड टू ना, वी, सर वी आर देयर टू असिस्ट द गवर्नमेंट डिपार्टमेंट एज वेल,
Yes,
राइट? तो हम,
absolutely. In the order itself it is written, a
जी
moratorium in effect.
बिल्कुल।
मेरे ख्याल से सुरेश जी 33(5) को रेफर कर रहे हैं।
हाँ, moratorium के लिए.
सर अगर आप मॉरेटोरियम के लिए भी कर रहे हैं, बट बीइंग अ लिक्विडेटर और अ आरपी, हमारी ड्यूटी तो है एक बार उन्हें डॉक्यूमेंट्स देने की।
Yes,
कैन कैन वी
we
डिनाई देम?
cooperate.
नो। सर मॉरेटोरियम है तो हम वो कोई आपकी असेट लेने तो नहीं आ रहे हैं, कुछ नहीं कर रहे हैं, वो आपसे डॉक्यूमेंट्स मांग रहे हैं और उसके बेसिस पे ही तो वो लोग भी क्लेम फाइल करेंगे ना।
We are ready to cooperate, but they can't instruct us. We are ready to
That,
cooperate.
that, that is true, sir. They cannot instruct us, they cannot boss us for this. We are here to cooperate. तो हम यही लिखते हैं हर बार मेल में कि since you have requested for this document and this is a duty of us, और as per the order specified जो है, हमें उसके बेसिस पे हमें आपको डॉक्यूमेंट्स देने, इतने टाइम में आप क्लेम फाइल कर दीजिए।
Right,
बट
absolutely.
उनका डॉक्यूमेंट्स, उनका क्लेम हमेशा बहुत बाद में ही आता है सर। एंड यू नो व्हाट हैज हैपेंड
लेकिन
इन इन माय अदर केसेस, उन्होंने सिर्फ क्लेम फाइल नहीं किया, उन्होंने ऑर्डर निकाल दिया सर, फॉर्म 7A 14B 7Q को ऑर्डर निकाल दिया उन्होंने।
मैडम अभी तो रेगुलेशन में भी आ गया ना, रेगुलेशन में भी आ गया कि ड्यू डेट के बाद अगर कोई अब इफ एनीबॉडी गिव्स यू एनी क्लेम ही हैज टू गिव रीजन। तो अगर आप मना करेंगे एनसीएलटी जाएगा फिर आप लेंगे, उससे अच्छा ले ही लीजिए आप क्लेम्स।
सर हमने तो ले लिया था ना, वी एडमिटेड टू इट। अगर उन्होंने हमें फॉर्म 7A में दे दिया कि आपकी इतनी लाइबिलिटी है, जो जो भी इसमें प्रीवियस आईआरपी थे उन्होंने एडमिट कर लिया उसे। नाउ
ठीक है
व्हाट दे डिड, उन्होंने 7Q और 14B का ऑर्डर निकाल दिया सर, इमीडिएट बेसिस पे। टू विच वी रिक्वेस्टेड टू द COC कि ये निकाला है उन्होंने ऑर्डर, हमें अपील में जाना है, नहीं तो हमें रिट लगानी पड़ेगी, आप उसके लिए अमाउंट अप्रूव कर दीजिए। द COC इज नॉट अप्रूविंग द अमाउंट टू फाइल अ रिट पिटीशन। दिस इज द आयरनी सर। वी वांट टू रिजॉल्व CD कि उससे मैक्सिमाइजेशन ऑफ वैल्यू हो जाए।
Yes,
So
it's a
these are certain things which we really face, as Deepak ji correctly said, like you were also correctly saying.
practical
जी
problems, practical problems.
Yes, that. So sir, यही मैं चाह रही हूँ कि let's have an interactive session so that
Yeah.
we can discuss on the problem जो अगर मैंने face नहीं करी है, आप लोगों ने करी है, I could learn a lot from you people. इसलिए I started with the word dignitaries, क्योंकि यहाँ सभी बहुत experienced लोग हैं. We can have a healthy discussion कि okay, अगर इसको ऐसे नहीं तो ऐसे कर सकते हैं क्या? जैसे अभी EPFO की लोग प्रॉब्लम लेके आए दीपक सर, he is very correctly saying, वो इंटरम क्लेम लेके आ गए, इन्हें IBC पता नहीं होता है सर इनके, और यहाँ हमें प्रॉब्लम आती है कि उसको कैसे करें। वंस वॉट एवर मेल वी ड्राफ्ट, वी हैव टू बी वेरी मच कॉशियस, इजंट इट सर? क्योंकि वो मेल की कॉपी ही लगती है सर वहां पे वाइल फाइलिंग द एप्लीकेशन। सो दीपक जी, आपने अभी क्लेम को एडमिट भी नहीं किया है ना, आप कह रहे हैं?
नहीं नहीं, मैंने नहीं किया, एडमिट नहीं।
और उन्होंने कुछ रिवर्ट किया अभी
ना,
डिपार्टमेंट
अभी
ने?
नहीं किया। इट इज अराउंड अ वीक और 10 डेज जब भेजा था मेल, तो अभी तक उन्होंने कुछ नहीं किया।
सर हो सकता है कभी भी आपको 7A का मिल जाए ऑर्डर, यू नेवर नो।
हाँ, राइट
डायरेक्ट
राइट।
दे देते हैं वो ऑर्डर, फिर आप उनकी अपील लगाते रहो, आप यही करते रहोगे सर, बिकॉज दे डोंट फील दे आर ड्यूटी बाउंड कि वो आपको रिवॉर्ड भी करते हैं, नहीं करते हैं सर। Anyways, thank you for your views. Now, I was discussing about this point. Extension of payment of balance sale consideration beyond 90 days to be disclosed in the auction notice. In the IBC, it is specifically written कि 30 days में आपको पूरा पेमेंट मिल जाना चाहिए, जो भी आपका H1 बिडर रहा है. If 30 days में नहीं आता है, along with 12% interest, विद इन 90 डेज उन्हें एंटायर पेमेंट करना है. अगर 90 डेज में भी नहीं कर पाते हैं, तो SCC अगर अलाउ करता है आपको, तो देन you can extend the payment of the balance sale consideration, but that needs to be disclosed in the auction notice. I hope I am clear till here.
Yes, sir. Yes, sir.
Thank you. Sub-regulation 1A of 31A of the SCC. Until the stakeholder consultation committee is constituted under regulation 31A, the committee of creditors, as per regulation, as per section 21, will act as a consultation committee, and the voting right remain the same as applicable in the COC. Because again, as on the liquidation commencement date, while doing the paper publication and all, you give the intimation after that to all the department, to all the COC member to file their claim again. Because the interest date changes from the CIP commencement date till the liquidation commencement date. Now, once the government department also files their claim, then the voting percentage will definitely change over here, as I initially discussed. Till that time, till the transition period, the committee of creditors act as a SCC. This ensures continuity in decision making during the transition period. Voting share of member of SCC. Voting share of each member is proportional to their admitted claim in the total admitted claim. Secured creditor who have not Suresh sir, your point over here. Secured creditor who have not relinquished security interest under section 52 does not form part of a consultation committee. Normally, whatever I have seen up till now in my cases, the secured creditor relinquish their security interest to be a part of the consultation committee, and they are treated as per the hierarchy of section 53 there. Promoters, directors, partners, or their representative may attend the meeting but have no voting right. FC or the representative who are related parties of the corporate debtor cannot vote. Representation in the consultation committee, nomination of representative as per regulation 31A3. Liquidator may facilitate stakeholders of each class, that is financial creditor and class, workmen, employee, government department, other OC, shareholders, partners, to nominate their representative for participation in the consultation committee. Normally what I practice is, along with the notice, I every time send a letter that to nominate one of the representative for participation in the consultation committee, and once I receive their nomination, then only I allow them to sit in the meeting. Failure to nominate. If stakeholder of a class fail to nominate their representative under sub-regulation 3, their representative shall be selected by majority of voting share of that class present and voting. Voting by representative under sub-regulation 3 or 4 shall vote in proportion to the voting share of the stakeholder they represent. That is okay. Sub-regulation of Stakeholder Consultation Committee 31A5. Representative entitled to all relevant record information to advise liquidator under sub-regulation 1. Meetings. First meeting within 7 days of the liquidation commencement date. Subsequent meetings as per liquidator discretion or on members request. Member कब request कर सकते हैं अगर उनके पास 33% voting right है. Just at least one meeting per quarter. Not later than 30 days from previous meeting unless extended by SEC. Would recommend that whenever the first SEC meeting is held or you convene a first SEC meeting, the maximum approvals, whatever are applicable as per regulation 31A, shall be taken by the liquidator so that हमसे कुछ छूट भी ना जाए जो ये regulation बोलता है और बाद में भी हमें problem ना आए. जैसे इसमें लिखा है कि at least one meeting per quarter. एक मीटिंग तो होनी ही चाहिए और नॉट लेटर देन 30 days फ्रॉम द प्रीवियस मीटिंग से गैप नहीं होना चाहिए. हमारे केस में हमने उनसे यही लिया हुआ है तो वो बोले हैं कि नहीं नहीं आप तो हर 30 days में कर ही लो एक मीटिंग, हमें भी पता पड़ जाएगा कि व्हाट इज द प्रोग्रेस इन दिस. Initiation of continuation of legal proceedings. Liquidator must present economic rationale before initiating or continuing any legal proceeding. Liquidator must seek advice of the stakeholder consultation committee. Now, here it is a must that you need to seek advice from the stakeholder consultation committee before initiating or continuing any of the legal proceedings. Periodic reporting to the committee. In every meeting, the liquidator shall, not may, shall present actual liquidation cost and justification for any excess over estimates, consolidated status of all legal proceedings, progress report on the liquidation process. We being a liquidator chair the meeting. Recommendation of COC. Liquidator must place recommendation of COC under regulation 39C of CIP regulation, assessment of sale as a going concern before SEC for information. Now, what regulation 39C says? While approving a plan under section 30 or deciding to liquidate the CD under section 33, the committee may recommend that liquidator may first explore sale of CD as a going concern, that is 32E, or sale of business as a going concern, 32F, if an order for liquidation is passed under section 33. Where the committee recommends sale as a going concern, it shall identify and group the assets and liabilities, sorry, which according to its commercial consideration ought to be sold as a going concern as per clause E or F of 32. The RP shall submit the recommendation of committee to the adjudicating authority while filing the approval or decision of a committee under 30 or 33 as the case may be. Just a moment. Now, 39C, I read it over here. I think it's clear. Voting on advice. SCC to advise liquidator by more than or equal to 66% of voting share of representative of the consultation committee. For the purpose of this sub-regulation, the term voting shall mean voting cast by the representative of the consultation committee. Either the consultation committee who is personally present, that can vote, or any of their representative can vote. Nature of advice of a consultation committee is not binding on the liquidator except for the legal proceeding that needs to be initiated or continued. At that point of time, we must take an advice of the stakeholder consultation committee. Else, that is not binding. Whatever advice given by the consultation committee is not binding on the liquidator. If liquidator takes a different decision, as I discussed initially, if any of the liquidator takes a different decision, he must record reasons in writing, submit records of such decision to the adjudicating authority and IBBI within 5 days of such decision made, and the same should be included in the next progress report. I hope I am clear till here. Anybody have any doubt or come across any such things, whatever we have discussed till now, are welcome to share his or her views.
Madam, one thing I want to ask you.
Yes, sir.
While submitting the claims, interest to be calculated up to the liquidation commencement date or CRP commencement date?
Sir, can you come again? आपकी आवाज बहुत कम आ रही है क्या?
Madam, when claim is filed,
हाँ,
interest is to be calculated up to the date of CRP commencement or liquidation commencement.
Sir, if in the liquidation process any of a claim has been received, then definitely it must be up to the liquidation commencement date, not to the CIRP date. CIRP commencement date के लिए जो हमारा CIRP process चलता है तब तक के लिए होता है. बाकी अगर किसी ने claim file किया है, then it is a duty again of the liquidator to teach them that okay, you need to file your claim, your interest till the liquidation commencement date.
Okay, madam. Thank you.
Okay, sir. Replacement of
Ma'am, I have a
Yes.
query. Ma'am,
Yes.
once we have admitted a claim as on the liquidation commencement date and due to certain facts coming up before the liquidator, at a later stage, she modifies the claim after
Correct.
for the adjudicating authority. Now, at whatever is the percentage that comes up thereafter, it has to be
Correct.
retrospective from the liquidation commencement date.
मैडम व्हाट आई कुड अंडरस्टैंड, आप ये बताना चाह रही है सुधा मैम कि आपको लेटर कुछ पता पड़ा, फिर आपने वो क्लेम लिस्ट में मॉडिफिकेशन किया तो वोटिंग परसेंटेज अकॉर्डिंगली वेरी हुआ.
Yeah, distribution percentage भी vary हुआ. I'm more
कौन सा
concerned
परसेंटेज?
about the distribution rather than the voting share.
डिस्ट्रीब्यूशन परसेंटेज भी वेरी होगा मैडम, बट आपको तो बाद में पता पड़ा था ना, उन्होंने फैक्ट्स बाद में दिए ना, तो व्हाट एवर डिसीजन वाज टेकन बिफोर दैट, दैट वाज नॉट वैलिड डिसीजन. डिस्ट्रीब्यूशन तो आपका फिर अकॉर्डिंगली जब उनका मॉडिफाई हुआ वो परसेंटेज, तो वो तो तब से एप्लीकेबल होगा सुधा मैम.
Starting से ना.
स्टार्टिंग से कैसे होगा मैडम? आप ये बात करें डिस्ट्रीब्यूशन की या वोटिंग परसेंटेज की?
Distribution के लिए.
डिस्ट्रीब्यूशन एज पर सेक्शन 53.
Yeah. To the
ओके,
assist.
तो मैडम देखिए अभी सपोज अगेन आई एम कमिंग बैक टू द सेम, आज 6 सितंबर है, राइट?
हाँ.
आपको आज के दिन पता पड़ा दैट देयर इज सम सर्टेन मॉडिफिकेशंस एंड अकॉर्डिंगली द वोटिंग परसेंटेज इज चेंजिंग, राइट मैम? You file this application to the adjudicating authority. Now that person is eligible. अभी जो वोटिंग परसेंटेज चेंज हुआ है तो सेक्शन 53 में तो जो वोटिंग परसेंटेज चेंज हुआ है तो डिस्ट्रीब्यूशन तो उसी के अकॉर्डिंग होगा ना मैम. You cannot go to the previous voting percentage then. But the decision whatever has been taken prior to this modification, तो वोटिंग परसेंटेज वही एप्लीकेबल होगा. बट सेक्शन 53 का डिस्ट्रीब्यूशन जो है, तो जो अभी वोटिंग परसेंटेज उनका चेंज हो चुका है वही एप्लीकेबल होगा और उसी हिसाब से इनिशियल डिस्ट्रीब्यूशन भी होगा.
आप कहना चाह रहे हैं मैम मॉडिफिकेशन होने के बाद जो डिस्ट्रीब्यूशन परसेंटेज आएगा वो उस समय से एप्लीकेबल होगा, उससे पहले जो उसको मिला या उससे पहले जो ड्यू था वो उसको उतना ही मिलेगा?
नहीं 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 मैडम, दैट इज व्हाट आई एम सेइंग. नहीं, आप आई थिंक आई एम नॉट वेरी, आई जस्ट कम अगेन. वोटिंग परसेंटेज सपोज करिए उनका 10% था, ओके, प्रायर टू योर मॉडिफिकेशन. मॉडिफिकेशन के बाद उनका 12% हो गया, राइट? तो उनको तो डिस्ट्रीब्यूशन ऑफ 12% के हिसाब से ही होगा ना मैडम, बिकॉज दैट इज ऑलरेडी बीन रिकॉर्डेड विद द आईबीबीआई एंड द एडजुडिकेटिंग अथॉरिटी. अभी आपका डिस्ट्रीब्यूशन तो हुआ ही नहीं था ना मैडम. डिस्ट्रीब्यूशन तो आपका 12% होने के बाद होगा सेक्शन 53 के अकॉर्डिंग. बट व्हाट आई एम सेइंग, व्हाटएवर डिसीजंस हैज बीन टेकन उनका वोटिंग परसेंटेज जो 10 था प्रायर टू दिस मॉडिफिकेशन, तो वोटिंग परसेंटेज उसके हिसाब से उनका वोटिंग परसेंटेज चलेगा जो भी डिसीजंस हुए हैं, बट फॉर द डिस्ट्रीब्यूशन विल बी एप्लीकेबल एज पर 12% ओनली. Am I clear now, Sudha ma'am?
एक चीज है, शायद मेरी कुछ कंफ्यूजन है, इफ यू अलाउ मी मैम. हमारा वोटिंग परसेंटेज आता है कंसिडरिंग ऑल द क्लास ऑफ शेयर होल्डर्स, ऑल द क्लास ऑफ स्टेक होल्डर्स, लाइक सिक्योर्ड, अनसिक्योर्ड, ऑपरेशनल, सबको कंसिडर होता है इन लिक्विडेशन, and everybody participates, and the percentage, like for secured, we have 68% secured, we have suppose 10% for unsecured, 2% for operational. Suppose this is the scenario.
Correct.
But when we go for distribution, it is first the secured financial creditors who gets the distribution.
Correct.
And distribution will be as per the distribution share of that class, like only that class.
Correct.
Yeah. Distribution percentage and voting percentage will be different.
Correct, ma'am. Correct.
So now when the I'm more concerned about the distribution percentage, ma'am. Voting percentage will not have an effect, and moreover, those matters that are already been voted, I cannot go and change those previous events percentage. But with
That's what I'm saying, madam, ki voting percentage need not to be changed. Whatever decision has already been taken upon that, right, madam?
Yes,
but
ma'am.
Distribution percentage will be as per the present percentage only, ma'am.
As distribution will be as per the present percentage that will come. So the entire distribution which was made previously has to be recalculated.
Madam,
right?
here, madam, I think there's some confusion. You are in which stage? Sudha ma'am,
Yes,
you are in which stage?
I'm at the liquidation stage.
No. Have you distributed?
Some portion has been distributed.
Yeah, ma'am, that's the confusion. She has already been distributed. Now something is coming up.
That is what, sir. Whatever has been distributed, after that any modification has added. So the present distribution has to be as per the present percentage, sir. How can we go according to that? Whatever has been distributed, that is over, because at that time the percentage was different. And now the modification has been made. Every details has been shared before the stakeholder consultation committee in the SEC meeting, to the adjudicating authority, to the IBBI as well. So whatever distribution has to be held, it is as per the present percentage it needs to be held.
Madam, it is been distributed. What she is saying, already distribution will take place. You have to take back from something and give to somebody.
No, sir. That जो हो गया sir, उसको आप लोग recall नहीं कर सकते हैं.
Yes.
That is what my point of view was there. And अगर इस पे किसी को कोई issue है, they are always open to file an application before the NCLT. Let NCLT adjudicate this matter and come out with whatever will be the outcome. But that is for sure कि जो present percentage है, जो already distribute हो चुका है, जब percentage अलग था, part distribution अभी हो रहा है, जब percentage अलग है, तो वो present percentage के हिसाब से ही होना चाहिए. Are we clear now, Sudha ma'am?
Ma'am, you are clear, but in my matter, there are different things also involved. Ma'am, according to what is my thinking is that this is CRP is a different matter where any modification that is done in between, from then onwards the percentage comes in, and in CRP period it is only the voting share which gets affected. But in case of liquidation, it's the distribution. Now, if in your claim, you have made certain claims which should not have been admitted, but because of that time, because of certain facts that were paid, which made you take those claims, but later you come to know that there was no money paid with respect to that particular claim, and it should not have been admitted, and you go for a modification of that claim. Now you go for the modification of that claim, and since all claim in case of liquidation liquidation, it is from the liquidation, as on the liquidation commencement date, that claim should have been there. So that when I'm modifying it is not an after event. It was to that date only. But since that time those facts were not in front of us, which came in the later stage, which made us revise or modify the claim. according to me, it should be from the initial date. Matlab, the claim should be revised from the initial date, and they should get their share of distribution only with respect to that claim. Please guide me where I am wrong, because this is CRP is different, where we can, any change which takes place, it cannot go back. It is from that day onwards. But in case of liquidation, since we are distributing, ऐसा नहीं हो सकता है कि उसको पहले 100 रुपए ज्यादा मिल जाए और उस पीरियड तक वो 100 रुपए ज्यादा ले लिया और बाद में उसने उसको कम मिला. इनफैक्ट वो 100 रुपए भी रिवाइज होना चाहिए with respect to the modified claim amount, because it is the same claim you are revising it. It is the same claim you are revising it.
मैडम द थिंग इज कि जितना आपने बोला, जो हम समझ पाए, सुरेश सर और मैं और बाकी लोग भी हैं, अब क्योंकि अब आपका एंटायर केस हमें पता नहीं है मैम, राइट? पर जितना आपने बोला है मैडम, अगर आपको जहां क्लैरिटी नहीं है, और आपके हिसाब से ही होना चाहिए, जो कि मेरे हिसाब से तो नहीं होना चाहिए मैडम, उसके साथ अनफेयर हुआ तो उन्हें वो क्लेम पहले फाइल करना चाहिए था, या जब मॉडिफाई किया तो आपने एससीसी के सामने ये सारी डिटेल्स पुटअप करी होंगी कि भैया ऐसे डिस्ट्रीब्यूशन हो गया है, नाउ वी नीड टू मॉडिफाई दैट डिस्ट्रीब्यूशन, और इनको अब इतना नहीं इतना मिलना चाहिए. क्या उस पर एससीसी ने अपना कंसेंट दे दिया? अगर एससीसी ने नहीं दिया, स्टिल बीइंग अ लिक्विडेटर, you feel कि नहीं, I should go before the adjudicating authority because SCC is not the ultimate authority to advise you. आप उनसे एडवाइस ले सकते हैं, बाइंडिंग नॉन बाइंडिंग, ये कोई जरूरी नहीं है कि वो बाइंडिंग होगा आप पे. आपको ऐसा कोई डाउट है, बेटर टू फाइल एन एप्लीकेशन, टेक एन एडजुडिकेटिंग टेक एन एडजुडिकेशन फ्रॉम एनसीएलटी टू बी ऑन अ सेफर साइड, जिससे आपके
Thank you
बाद
so
में
much, ma'am.
litigation ना हो
Thank you
मैडम.
so much.
What
Thank
I
you so
feel is
much, ma'am.
मैडम,
This
क्योंकि
was a
मुझे
good
देखिए आपका
clearing.
टेस्ट नहीं पता है अभी क्लेम का, आपका मुझे पूरा सिनेरियो नहीं पता है, सो अभी मुझे ऐसा कोई प्राइमा फेसी उस चीज को लेके कोई फाइनल कंक्लूजन देना, दैट वुड बी नॉट गुड ऑन माय पार्ट. बट जो इनिशियली समझा उस पर मैं जरूर ये कह सकती हूँ, फिर भी इफ यू आर फीलिंग बीइंग अ लिक्विडेटर बिकॉज यू आर देयर एज अभी आप उनको पूरा डिसाइड करने के लिए आपको अथॉरिटी है, आपको कहीं भी डाउट लग रहा है, यू आर ऑलवेज फ्री टू गो बिफोर द एडजुडिकेटिंग अथॉरिटी, फाइलिंग एन एप्लीकेशन. लेट्स सी व्हाट एनसीएलटी डिसाइड्स.
Madam, another thing, if there is any change in voting share, it has to be prospective, not retrospective.
दैट इज
Yes.
व्हाट सर आई टोल्ड. इसीलिए जो
Yeah.
आपने और हमने बोला उनका केस समझ के कि अब जो बैलेंस डिस्ट्रीब्यूशन है वो प्रेजेंट वोटिंग शेयर पे होना चाहिए,
It
जो
has
हो
to be
चुका
prospective.
है
It has to
नहीं
be
कर.
prospective.
दैट हैज टू बी प्रोस्पेक्टिव. दैट इज व्हाट माय वो मतलब यही मेरा भी कंटेंशन है. बट सुधा मैम को फिर भी कोई डाउट है, तो इसीलिए हम मैं तो ये सजेस्ट करूंगी मैम कि मुझे भी अगर कहीं भी डाउट रहता है, आई बेटर फाइल एन एप्लीकेशन बिफोर द एनसीएलटी, टेक एन एडजुडिकेशन और डिसीजन और देयर व्यूज कि ऐसा नहीं ऐसा होना चाहिए. और अगर वो बोलते हैं कि एक्ट में लिखा तो है, आप तो एक्ट के अकॉर्डिंग ही करिए, तो देन वी आर फ्री टू डू, एटलीस्ट वी हैव एन ऑर्डर विद अस फॉर अ सेफर साइड. इज इट ओके सुधा मैम?
Ma'am, this was really helpful for me. I think it's better I place it before the adjudicating authority. I'll be
दैट
on
वुड
the.
बी ग्रेट. प्लीज.
Thank you so
ओके,
much. Thank you so much.
थैंक यू मैम. वी रियली फील गुड कि अलग अलग टाइप के जब लोगों के पास में ऐसे कंफ्यूजन स्टेजेस आती हैं वेर वी आर नॉट वेरी क्लियर, एक्ट भी उस पे ऐसा कोई स्पेसिफिक नहीं बोलता है, हम अपना माइंड लगा के भी अगर कर भी लेते हैं चीजें, बेटर टू हैव अ कंसेंट फ्रॉम द हायर अथॉरिटी. नाउ, replacement of a liquidator. Consultation committee may propose to replace liquidator, requires not less than or equal to 66% of majority vote. Reasons must be recorded. File an application before adjudicating authority. Written consent of a proposed liquidator. Where replacement is proposed, current liquidator shall continue till the replacement. She shall be suitably remunerated for work performed. चलिए कम से कम ये तो लिखा है कि हमें एक suitable remuneration मिल जाना चाहिए. Transitional provision. If SCC was already constituted before the second amendment of 2022, liquidator must reconstitute SCC within 30 days as per amended regulation. New provision apply only after such reconstitution. Now I think we can take a break for 15-20 minutes if everybody agrees, and after that we'll be continuing with our second session, that is the liquidation estate under
Yes,
section
please.
36.
Yes,
Okay.
yes. Agreed.
So
Agreed.
I think we can come back. What time will be suiting you? What time you want us to be back and start with this session again?
It is 15 minutes.
15 minutes. So it is 12:20. We'll be here by 12:35.
Yes,
Okay.
please, please.
Okay. Okay. See you then. Okay.
Okay.
After 15 minutes. Thank you. think we can start with the session.
Yes, ma'am.
Okay. Everybody are there?
Yeah, we are here, ma'am.
Okay. So now coming to our next topic, that is liquidation estate. Because while distribution, we need to form a liquidation estate. उसी basis पे आप क्या amount और क्या properties liquidation estate में form कर सकते हो, तभी आप distribution कर पाओगे as per section 53. So this is important one. Just a moment. Yeah. I hope my screen is visible to you all. Can anyone give a confirmation?
Yes, ma'am.
Thank you, Prashant ji. Coming to liquidation estate under section 36 of IBC, formation of estate. For liquidation purposes, the liquidator shall form an estate of assets mentioned in 36(3). This shall be called as a liquidation estate of the CD. This is the fiduciary duty. We as a liquidator holds a fiduciary duty for the liquidation estate, and this is done for the benefit of all the creditors. Inclusion in the liquidation estate, what all properties, assets are to be included. This has been specified in 36(3). Assets with ownership right of a corporate debtor. This is an important topic. Please, everyone pay attention. Assets with ownership rights of CD, including rights and interest that is recorded in the balance sheet, information utility, registries or the depositories. Other record as specified by the board also include share held in subsidiaries. Means if a company is holding a share in any of its subsidiaries, for that purpose, that shares that is held in the other subsidiary of the same company can also that also needs to be a part of a liquidation estate. Assets in possession or not in possession of debtor, including encumbered assets. Whether the assets are in possession of a corporate debtor or not in possession of a corporate debtor, but it is owned by the corporate debtor, although the assets are under dispute, although that is an encumbered asset, also needs to be formed part of a liquidation estate and can be used for the recovery purpose, and out of that recovery the amount can be distributed. Tangible assets, movable or immovable. Now, coming to the intangible assets, including but not limited to. So, here it is specifically written in the act that it includes but not limited to, means besides this also, if some other intangible assets come into the picture, that also forms the part of a liquidation estate. What is there? Intellectual property, securities, including shares in subsidiaries, financial instrument, insurance policies, contractual rights. Assets that is subject to ownership disputes. Assets whose ownership is to be determined by a court or authority. Any of the property dispute, that is the matter is sub judice before any of the court or any of the other authority. So that can also, that needs to be a part of a liquidation estate. Assets recovered through proceedings for avoidance of transactions. So if there is any PUFA application filed during this AIRP, that also, if the assets gets recovered, whether through the bank account or any other physical assets are there, that also needs to be part of a liquidation estate. Asset with relinquished security interest. Assets in respect of which secured creditor have given up their security interest. If they have relinquished their security interest, definitely it is under the possession of the CD now, and that also needs to be formed part of a liquidation estate. Any other property belonging to or vested in the CD at the insolvency commencement date. All proceeds of liquidation as and when realized are the parts of liquidation estate. 36(4) exclusion from liquidation estate. the following assets shall not, okay, it is not written may not, shall not be included in liquidation estate and cannot be used for recovery. So they are to be kept outside the liquidation estate and they simultaneously cannot be used for any recovery. Assets owned by third parties but in possession of CD. Assets held in trust for any third party. Assets under bailment contract. All sum dues to workmen employed from the Provident Fund, Pension Fund and Gratuity Fund. If any of the fund is created in favor of such workmen and employee in the books of the CD, so that fund cannot be used or cannot form part of a liquidation estate. Contractual arrangements allowing use of assets without transfer of title. Any of the contractual arrangements have been made, okay, for the timing you can use the machinery of a third person. So this is a contractual arrangement ki when the machinery use is over, you can give that back for a particular time. Such arrangements are made. So that doesn't mean that there is a transfer of a title. Any other assets notified by the central government in consultation with the financial sector regulator. Assets and security, collateral of the service provider subject to netting or and setting off in multilateral trading clearing transaction. If the security has been held as a collateral security and the amount needs to be paid and some amount need to be taken from them. So in that way, some set off can be done and the balance amount that needs to be paid to the other party cannot be a part of a liquidation estate. Personal assets of shareholders, partners, provided they are not held on account of the avoidable transactions. Provided word is used over here. Assets of Indian or foreign subsidiaries of a corporate debtor. Any other assets as may be specified by the board, including assets subject to set off on account of mutual dealing between the corporate debtor and any other creditor. Now, I think I am clear. You want any discussion to be held for the liquidation estate that are included or not included in the liquidation estate? Or any of the people have come across that, okay, we have faced this challenge, whether this assets to be included in the liquidation estate or to be excluded?
In one of my matter, this litigation is going on, the property is in dispute.
Okay.
CD is fighting. I have taken custody. Title is not decided.
Title is not decided by the court, right?
Right.
But correct, sir. So as we have discussed, if there is any disputed property that is under adjudication before any court or any authority, that also form part of a liquidation estate until the
Exactly.
matter comes up from there. And
Exactly.
if there is any of the deed which is registered in the name of a CD, but still in dispute, so for that time we can keep that thing pending, but definitely it will be a part of a liquidation estate. I think I like you must also have taken the same plea.
No, why can't I sell my right? Whatever right the company is having, now it is with the liquidator.
Okay, correct.
So can't I sell my right?
How can you? Acha, your right can be sold. I think, sir, definitely it can be sold because it is specifically been mentioned. Let me just go through that again and we can have a discussion on that. Yeah.
Yeah.
Point number E. Asset
Hmm.
subject to ownership dispute. Asset
Yes.
asset whose ownership is to be determined by a court or authority. So the
Yes.
matter is sub judice before the court. But
Yes.
if so the title is not clear, so definitely you can sell that right.
Exactly. That's what I'm doing.
That has specifically been written, sir, in the act.
Yes.
So I don't think
Yes.
there is any second thought about
No,
it, right?
they're disputing, they're putting a senior advocates and all that is going on.
Okay. But definitely you have the authority to sell that, right?
Yes, ma'am.
Sir.
Even what I did while I published my tender notice, I had mentioned everything about the disputes, including the case numbers.
Correct. Sir, same thing I have also done in the process document,
Yeah.
including the case numbers and what is the present
Yes.
scenario going on
Exactly,
in the court. I have already disclosed each and everything. It is better to give a
Yes.
proper disclosure to safeguard
Yes.
our skin.
We don't want to
Correct.
mislead anybody. I don't
Correct,
want to
sir.
mislead anybody.
Correct, sir. That should be our criteria being a liquidator because we are a court-appointed officer. We have got a lot of responsibilities and we
Yes.
act in a, it has already been specifically written in the act itself that we act in a fiduciary capacity, sir.
Yes, ma'am. The bank initially disagreed. Then why you wrote this? Nobody will come. Then I
Correct, sir.
said,
Correct.
I said, I can't mislead anyone. Tomorrow
Correct.
he will go. He will come after me.
Very,
And-
very correctly said, sir. Thank you. Thank you, sir.
Okay.
Thank you for your views. Now, there are certain judgments. उसमें एक दो मेरे ही case laws हैं. We'll be discussing it on the Stakeholder Consultation Committee and Liquidation Estate. Case title is Sanil Prakash Sahu ex-workman versus Ms. Chaya Gupta, liquidator, Gwalior Polypipes Limited. Order dated 8/8/2025, NCLAT Principal Bench. Director of Gwalior Polypipe Limited was Mr. Sanil Prakash Sahuji. Claimed employees' dues. Liquidator rejected their claim being belated. NCLT dismissed IA 85 of 2025, insufficient explanation for delay. Then the director filed an appeal before the NCLAT. NCLAT finding was 19(4) Mendes liquidator to admit employee workman claim from books of account even if no claim is filed. As I discussed about 19(4), that it is written over here that liquidator may admit the claim of a workman or an employee on the basis of books of accounts of corporate debtor if such workman or employee has not made a claim. There is no word written as shall or mandates. Okay. So on this basis, I have not admitted their claim because I couldn't find a proper backing for their claim. So on that basis, they have filed an application to NCLT. NCLT also dismissed their application. On that basis, they went to NCLAT. And the NCLAT told that delay does not bar consideration. No prejudice caused and assets yet to be realized. Okay. So order was that appeal was allowed. Liquidator directed to examine the claim on merits. So again, I have asked them that, okay, you submit me the proper records. Let me go through because it has already been directed to me that to examine the claim on merits. Because here the word may is used, right? So such thing also needs to be taken care of. Coming to my next case, that is Commercial Tax Department versus Liquidator of Gwalior Polypipes Limited, order dated 4/7/2025. Background of the case was application I number this filed under section 42 and 5 of Limitation Act. Relief, what they sought means the commercial tax have sought condonation of 34 days delay in filing an appeal. Firstly, they have delayed in filing an appeal. For that, they needs a condonation. Condonation of 68 days delay in submitting claim to the liquidator. NCLT rejects their claim, setting aside rejection of claim dated 17/1/2025 by the liquidator. So I have not accepted their claim for the reason that they haven't filed their claim within the timeline of 30 days. Then the prayer was to accept the claim of 10.72 crores. Claim earlier submitted to RP and admitted. Liquidator rejected claiming delay. Now, NCLT filings was applicant shows sufficient cause of delay, no prejudice caused, asset yet to be realized, delay 34 days plus 68 days in submission condoned order. Liquidator directed to reconsider claim of 10.72 crores. Verify whether claim was admitted by RP. Issue fresh reasoned decision within 7 days and file compliance report in 10 days. So what I did in this, whatever claim was admitted by the RP, I have admitted it to that extent, and for the rest of the amount, I have asked for a detailed reason and the supporting documents which the commercial tax is yet to file it, and I've already filed the compliance report as per the court order. Case title, a similar case was there in 2023, Canara Bank versus the Commercial Tax Department. Tax Department filed the claim in CIRP but submitted on 19-day delay. Liquidator reject the claim as time barred. Adjudicating authority condoned the claim, condoned the delay and admitted the claim. Then again Canara Bank appealed against this order. Key arguments were delay beyond statutory period not condonable. Relief on SC, State of MP versus Bherulal. 63-day delay cannot be condoned. Key argument respondent that the tax department delay was minor 19 days. Claim was genuine, already admitted earlier in CIRP. Now comes the NCLAT findings. Section 42 of IBC, appeal period 14 days, delay can be condoned under Section 5 of Limitation Act. Case is different from Bherula, long delay versus short delay, no gross negligence by tax department. So NCLAT had ordered that delay rightly condoned by the adjudicating authority, liquidator directed to accept the claim. Now coming to EPFO versus Mr. Subodh Kumar Agarwal, RP, MB and Computronics. Date of order 27/5/22.
Madam,
Section 36 of...
may I interrupt? This
yes.
this
Yes,
this PPT you will be sharing with us. Na first two cases I need the citation.
Sure, sir, sure.
Thank
I'll be
you.
sharing PPT. First two cases मतलब आपको हमारे cases चाहिए ऐसा sir?
No, this is not your case. Whatever has been held, I want to go into detail.
Sure, sir. Please.
Please. Thank you.
I'll be sharing the entire PPT.
Thank you
Don't
so
worry.
much.
Thank you. It is the statutory obligation of CD to contribute to workman and employee due toward the provident fund, pension fund and gratuity fund. वो अभी हमने डिस्कस किया कि वो फंड्स को आप लिक्विडेशन एस्टेट के बाहर रखेंगे. If such funds are deficient or unpaid, CD must make the payment. These amounts are kept outside the liquidation estate, right? Section 36 for in another case, Sunil Kumar Jain versus Sundaresh Bhatt. Section 36(4) of IBC provides outright protection to Provident Fund, Gratuity Fund, Pension Fund. The liquidator has no claim over these funds. They cannot be used for recovery in liquidation. Coming to another important case law of Welspun Steel Resources versus UBI versus Union of India, sorry. 17/2/23, Section 36 allow authorities to attach properties acquired by successful bidder in liquidation on mere presumption of criminal activity would harm the value maximization objective of IBC, would reduce chances of finding a willing resolution applicant or liquidation bidder. आप सिर्फ mere presumption है कि कोई criminal activity होगी, उसकी वजह से you cannot attach any such properties of a successful bidder. सर आपके पास कोई और केस लॉ है जिसपे अपन डिस्कशन कर सकते हैं, क्योंकि मुझे जो अवेलेबल केस लॉस लगे और इंटरेस्टिंग लगे विद रिस्पेक्ट टू दिस आई हैव डिस्कस्ड ओवर हियर. इफ यू हैव कम अक्रॉस आप ही के केसेस में या आपको कोई और पता पड़ा हो कि दिस वाज आल्सो एन इंटरेस्टिंग केस लॉ व्हिच कैन बी डिस्कस्ड ओवर हियर. एनीवन? कोई अपना एक्सपीरियंस शेयर करना चाहेगा अगर? Yes, sir. I was waiting for anybody's queries or their challenges which can be shared on this platform. because whatever I had to discuss over here, I had already discussed with respect to the liquidation estate is such a ऐसे बहुत wide topic है liquidation estate once while you need to do some distribution under section 53 but if you say verbally और हमें discussion करना हो यहाँ पर as per the act it is not that big जो nuances हमें देखने हैं वो distribution के time पे we need to have a gross check over each and every assets.
And with respect to certain liquid assets in the form of fixed deposits,
Okay.
which were not pinpointed or taken into account by the RP and which are coming up before the liquidator from 26 AS.
Okay.
These deductions हो रहा है, and from the deductions we find that these there are certain fixed deposits which we're not aware of.
Mm-hmm.
When till date I'm not able, the bank is not able to find out and give it to me which are these liquid assets. Now,
Okay.
these are my new revelations. I have not yet included in my asset memorandum. They were not included in the asset memorandum.
Okay, ma'am.
So, since it is not included, क्या मैं कभी भी I cannot make it as a part of the liquidation estate, or when I I recover them and then I revise the asset memorandum, and then it can be a part of the liquidation estate.
Madam, you have very correctly inquired because as of now you have not included in the asset memorandum because you were not aware of it. As in when you came aware of it, have you put the same before the SEC?
Yes.
So whatever they are suggesting on this कि okay ये asset है but अभी हमें नहीं पता पड़ेगा because liquidation is not an ongoing process madam कि हमेशा नहीं चलता रहेगा liquidation right तो as in when the FD you recover क्योंकि क्या बैंक भी आपको इतना ज्यादा कोऑपरेट नहीं करेगा मैडम इन वन ऑफ माय केसेस में 3 साल से मुझे 2.5 लाख रुपए लेने हैं वो कंपनी के पैसे हैं 3 साल हो गए मैडम लिटरली मुझे उस केस में बट आई एम नॉट गेटिंग दैट मियर 2.5 लाख रुपए वो बोल रहे हैं कि अभी तो लीगल में गया है यहाँ गया है या तो मैं कोर्ट में एप्लीकेशन लगाऊं फिर करें हर चीज के लिए कोर्ट में एप्लीकेशन लगाना भी डजंट साउंड गुड दैट यू आर नॉट केपेबल ऑफ डूइंग द थिंग्स ऑन योर ओन बट अनलेस एंड अनटिल वी फाइल एन एप्लीकेशन ये लोग भी मूव नहीं करते हैं कोई भी बैंकर को वो सिंसियरिटी नहीं दिखती है आपके केस में अगर एफडी आपको रिकवर होने वाली है इफ द बैंक इज कोऑपरेटिंग दैट ओके नेक्स्ट 10-15 days और विद इन अ मंथ टाइम वी विल बी लेटिंग यू नो दिस तो देन यू हैव टू मेक दिस अवेयर अगर आपके पास कोई सक्सेसफुल बिडर भी आ चुके हैं इज दिस द केस दैट द सक्सेसफुल बिडर इज देयर एज ऑफ नाउ
Ma'am, in my matter, I have not put the corporate as a going concern as of now because this is a peculiar matter because I am still making many recoveries. So it is only
मींस यू
after.
मस्ट बी हैविंग चांसेस कि 5-6 महीने तो लग ही जाएंगे अभी आपको स्कोर करने में
हाँ. I have time.
हाँ तो देन डेफिनेटली आप उसे अभी एससीसी में करके और आप असेट मेमोरेंडम में ये क्लॉज भी डाल सकती है विद रिवाइज असेट मेमोरेंडम मैडम व्हाट आई फील इज दैट इज द बेस्ट वे मैडम या आपकी नेक्स्ट प्रोग्रेस रिपोर्ट में आप उसे शो कर सकती है राइट मैम ओके थैंक यू दीपक सर यू वर अबाउट टू से समथिंग
Yes, I just wanted to say कि कुछ NRI पर डिस्कस कर सकते हैं if company is having nothing or say liquidation value of 2-3 lakh rupees.
ओके
So whether NRRA is to be considered by the SCC? I have not dealt with the NRRA thing.
सर एनआरआरए के लिए हमने हमारा जो इनिशियल केस था उसमें हमने उनको बोला था कि आप या तो एनआरआरए करवा लीजिए सर इसे राइट वो नहीं है एज एन मैन इट विल बी रिकवर्ड आप इसे असाइन करवा दीजिए किसी को भी द सेम थिंग आई हैव डेल्ट बट एससीसी रिफ्यूज्ड बोले हम नहीं करेंगे जहां असेट्स नहीं है कौन आएगा बोले एनआरआरए हमारा आप और खर्चा करवा देंगे उसमें मैंने कहा हम आपको लाके देंगे ना सर बोले वी आर नॉट इंटरेस्टेड इन इट तो इट इज एज यू टोल्ड कि वी कैन पुट ईच एंड एवरीथिंग बिफोर द एससीसी नाउ इट इज अप टू एससीसी कि वो किस हिसाब से उसे टेकन अप करते हैं
तो
We try to
एनआरआरए
make
में
it-
क्या चीजें हो सकती है डेटर्स हो सकते हैं पुफे एप्लीकेशन हो सकती है
करेक्ट बट आपको उसके लिए असाइनी भी तो मिलना चाहिए ना सर जो ये राइट असाइन करने के लिए रेडी हो
ओके
दैट इज ऑल्सो क्लॉज सर जैसे हमारे इसमें असेट्स ही नहीं थी तो हमने रिक्वेस्ट करी कि अभी हम बोल देते हैं जो भी प्यूफे का आउटकम आएगा फिर वो ले लेंगे आपको एक they will be paying you lump sum amount as of now. तो they were told, बोले आपको कोई मिलता हो तो कर लीजिए, we are not interested, we will not go and seek to any of the ARCs या कोई हमारा असाइनमेंट लेने के लिए, वो होमवर्क भी बोले आपको ही करना होगा. बट जहाँ असेट्स नहीं होती ना सर, वहां बहुत दिक्कतें होती है. आपको आपका कोई प्रूफ ले या कोई डेटर उठा ले, कोई भी ARC या असाइनी जो रहते हैं असाइनर्स, दे आर लाइक प्रेजेंट दिखता है उसी में वो करते हैं सर टच. व्हाट आई हैव गॉन थ्रू फ्रॉम लास्ट 4 years, दिस वाज माय एक्सपीरियंस. अगर आपको मिल जाता है कोई भी NRRA के थ्रू, तो देन नथिंग लाइक इट सर. Any other
It is difficult actually to
very
find.
difficult sir,
it
very
is-
difficult because I tried for a year to
अच्छा.
find the assign. हाँ, मैंने ARC से भी बात करी थी कि आप ये सिचुएशन है, आप कर लीजिए, ओके we'll seek the approval from our higher authority and then get back to you. कि जहाँ assets नहीं होती, it is difficult. assets है वहां तो बिल्कुल मिल जाएंगे आपको असाइनमेंट उठाने के.
And further debtors are not realizable till now. तो अभी वो और कौन इंटरेस्टेड होगा डेटर्स को लेने
नहीं
के
होता है
लिए?
सर. अभी in one of my cases, I was in IRP and RP in that matter. There are no assets, although debtors were there of more than one CR. I have mailed them. I have sent them a legal notice. Okay, they are
Right.
not coming to me. I tried to seek a resolution plan. There was 2 PRA who came कि भाई डेटर्स है, आप लोग इसे देख लीजिएगा बाद में जो भी PRA है. बट दे आर लाइक कि आपने इतने एफर्ट्स कर लिए नहीं है, हमें कल को क्या पैसा दे जाएंगे, आपके पास कोई असेट्स तो है नहीं, सिर्फ डेटर्स हैं. तो विद दिस द COC डिसाइडेड कि नहीं, आप तो इसे डायरेक्ट डिसोल्यूशन में लेके जाइए, नॉट टू गो इनटू द लिक्विडेशन में भी मत लेके जाइए आप इसे. अननेसेसरी हमारे पास पैसा नहीं है, हम नहीं बेयर करेंगे. सो देयर आर दीज सॉर्ट ऑफ केसेस, ऑल्दो देयर आर डेटर्स, वो प्रेजेंट भी हैं बट वो अमाउंट देने को ही तैयार नहीं है, तो या तो सिविल सूट फाइल करो आप. तो जो भी PRA आते हैं, दे आर लाइक कि हम वो सूट फाइल करें, आउटकम कब आता है कब नहीं, व्हाई टू इंडल्ज, जो प्रेजेंट दिख रहा है हम उसी में ही जाएंगे. सो विद दैट रीजन दे बैंक. सो यू आर करेक्टली सेइंग कि डेटर्स का भी रियलाइजेशन कब होगा कब नहीं, दैट इज नॉट श्योर. प्यूफे का कब होगा नहीं होगा, नोबडी इज श्योर. तो ऑन दैट बेसिस ARC doesn't want to indulge into this practice. You are correctly saying, Deepak sir.
So the best way is to take the approval from the SCC and
Correct.
file early dissolution or dissolution application as the
Whatever
case may
is
be.
what, yeah, definitely sir. जहाँ assets नहीं है,
हाँ.
क्योंकि I am the ultimate sufferer of this, so it's my humble request कि आप SCC को convince करके dissolution file कर पाएंगे at the earliest without any further delay, sir.
Right. Thank you. Thank you.
Thank you, Deepak sir. Any further query? So I think आज हम almost 45 minutes पहले ही सेशन को क्लोज कर रहे हैं, क्योंकि कोई अभी जितना उसमें हमें जो टॉपिक दिया गया था, we have discussed maximum of it. Consultation committee consent for this.
Right.
Okay.
Agreed.
Okay. Thank you.
Thank you,
Thank you
please.
all.
Thank you.
I'll be sharing the PPT with ICSI triple IP.
Thank you, madam.
Thank you. Thank you, Damodar sir. Thank you all. Thank you,
Thank
Anjali
you
ma'am.
very much, ma'am, for your learning and for your experience you
Thank
have
you,
shared
ma'am.
with the participants. Thank you very much, ma'am.
Thank you. Hope to
Ma'am,
see you
please
all.
share the PPT with me.
Sure. I'll be sharing the PPT. Okay. Once again, I am highly grateful to all the participants. Thank you all. Good day.
Thank you, ma'am.